Just a couple of quick reactions, and then I'll open it up for everyone. You know, the Max Edling book, I admit I haven't read as much as I have, and it was kind of embarrassing to have like a renowned historian commenting on a paper where obviously I'm not as well versed in the historian. My one reaction to that is, in the paper I do talk about the difference that political theorists outline between external balancing strategies and internal balancing strategies. And internal balancing is the idea that you build up weapons and build up your military-industrial complex. External balancing is the idea that you use alliances, treaties, and fancy footwork, so to speak, to make up for your power deficit. And I associate the Tom Cruise Hamiltonian military-industrial view to sort of like a principally internal balancing focused strategy, and that the use of Article 3 and the J perspective was much more of an external balancing kind of orientation. I mean, that's obviously a simplification, but I do feel that there is that aspect of it. And I'm really heartened that you agree about the judicial power, because obviously the takeaway today is people generally think that the courts have no business in foreign policy. And one of the points I want to say is that's absolutely wrong. I mean, as an originalist matter, I mean, the courts were designed to be foreign policy institutions. The only aspects of their jurisdiction that Congress cannot take away are ambassadorial cases and status party cases. I mean, you know, who do they put on there? They put on their number one diplomat, their John Jay, surviving diplomat, because Franklin had died, and they put on, and James Wilson, their number one international law professor. Oliver Rutledge fell because he objected to the Jay Treaty, and Ellsworth left to become minister to Spain. So you sort of see the courts as an institution that was designed for foreign policy. Now, does that mean today we should just say the courts should wait until all this and we don't worry about them? And you know, I remember before I went to law school, I was in the intelligence world, and I remember walking into the John Jay room at CIA headquarters in Langley, and I was like, well, which John Jay is this? And Jack probably knows this, but John Jay used to be the head of counterintelligence for the United States in the Confederate period, or so the CIA told me. So I don't know if they're claiming as one of their own somebody who really wasn't one of their own, but there used to be a John Jay room at Langley, but. So I think that's actually a pretty important point. Dire geostrategic circumstances, I admit that's hyperbole. But the U.S., I mean, it was in bad shape, and I think that things changed a lot. I talked in the paper about the 1794 Naval Act, where they commissioned the frigates. And then there's the Legion Act, where they raised the Legion of the United States. I think that happened in 1790. And so, you know, frigates, they were small frigates, but they were sort of the nuclear weapons of their day, and they've sort of voted appropriations to really get state-of-the-art weapons. And so I think that right after, it's kind of like looking at the United States during the height of the Cuban Missile Crisis and Entente. And I think that basically between 1787 and 1793, things were looking really grim, and then 1794, things started looking a lot better. And so then you sort of get into a discussion of what the time frame is for figuring out when original public meeting should be. But it is interesting that there is this difference. But anyways, that's all.
I thought Tom's paper was fascinating and very suggestive, and that you've seen something that other people haven't made much of. Let me start off by asking you to say a bit more about how determinate you think the implications of this might be. You hint that the weak state backstory of the Constitution tends towards at least some support for various policies which I suspect you favor. You mentioned accepting a lot of delegation, for instance, of power to international organizations and institutions. And you imply at various points in the paper also a sympathy supported by this for accepting what I would call the NGO view of customary international law. Couldn't a bad person, I come to mind, tell an opposite story? namely that the weak state backstory made delegation, for instance, to international organizations radically inconsistent with the weak state preoccupation with sovereignty and with American exceptionalism.
So sort of an insecurity complex, so to speak?
With much to be insecure
about. Right.
Or as for the ambitious NGO version of customary international law, the customary international law should be kept to an absolute minimum. And you actually talk about that in a couple of points. Interesting, like the Soviet Union, whose foreign policy was always to put the highest possible emphasis on treaties, which the Soviet Union could have choice about, could have input into, and to minimize customary international law. That so likewise, the weak state constitution of the U.S. would disfavor today's ambitious ambitions for customary international law.
No, I think that's absolutely right. I mean, I think in the U.S. At founding, Franklin had this thing called the Model Treaty, and basically the United States was very suspicious of customary rules, and because they thought they were England favoring, and so when they cited Vattel's book, who was a Swiss writer, and he actually Kant condemns him as someone who justifies the status quo, but he actually had a normative project because he was a Swiss and he was worried about Prussian sovereignty over Neuchâtel, which is where he was a citizen of, and so he actually, if they looked at custom rules, they liked his book, right? So they didn't like sort of the English custom rules. So I think that's right. I mean, there's a clear preference for treaties over customary international law. The other strand, though, is because of this concern about denial of justice, there was a legal claim, an international legal claim called denial of justice, which we still have. People don't know a lot about it, but basically a foreign country could attack you if their subjects were denied justice in your courts. And so even though as a formal legal matter, the customary international law wasn't a rule, there was this incentive to bring your court system in line with standards of justice as a general matter. And that was actually a big reason for creating the federal court system, right? So I agree with you. And I mean, and this is something that I should clarify, and which is why I started with the Alien Tort Statute. I'm not sort of a pro do-gooder international law visionary. In fact, I think the Alien Tort Statute, I mean, and Mike knows this well, I mean, international human rights litigation in the federal courts under the ATS, I think it's wrong as an originalist matter, it's wrong as a normative matter. I mean, I can't see any justification for that. But at the same time, all I want to say is these people say, well, courts have no business in foreign policy, or you shouldn't look to international law to construe domestic standards. I mean, that has no real backing if you're an I mean, that if you scratch under the surface for that, that is equally bankrupt from an originalist perspective, I suggest.
Let's move on to the queue, and Keith and David Ledger and Garrett Epps. So others of you, Mike, let's start out with Keith.
So I thought the paper was really intriguing, and and I would start by really seconding everything Jack said, which was a lot of what I was thinking as well. And I guess one, and including emphasizing the Max Edling book, because that was the first thing that occurred to me as I was reading the paper. And part, I think, of what I would say about Edling, in addition to sort of the footnotes that Edling's building off of, so the earlier scholarship that he's also going to sort of resurrect and build on as he's doing his work. But part of what I think is relevant thinking about it is how you want to frame your paper as a whole. I think actually trying to frame it in terms of the originalism hook struck me as the wrong way of approaching the paper, or it didn't strike me as the most useful way of approaching the paper. Instead, the sentence that Jack pointed to as your first sentence struck me as the angle you ought to take, or points to the angle that the paper ought to be taking, which is to set up more specifically a set of hypotheses that you want to grapple with as to what kind of constitution would a weak state have as opposed to others? How might we model constitutions structured by different kinds of states in different kinds of situations? What are the kinds of constitutional choices you might make in different kinds of geostrategic situations? And does the U.S. and where does the U.S. Constitution fit under this? So, what kinds of expectations might we have about a set of constitutional founders in a given kind of geostrategic situation, and to what degree does the U.S. Constitution fit within that kind of set of expectations? I think in part that the paper right now suffers a bit from not being very clear about what the alternative expectations might be.
Right.
So you lay out a little bit what the expectations might be from a weak state model. Mm-hmm. It's not entirely clear what the expectations might be from alternatives to the weak state model, and how well the U.S. Constitution actually fits those alternatives as well. And it's not entirely clear, I think, what the how the U.S. Constitution as well builds off of its own prior history. So, for example, even as you sort of say the U.S. Constitution fits these weak state models, I was also thinking, well, how does it compare relative to the prior choice, or the prior, the status quo that existed prior to the U.S. Constitution, which is the Articles of Confederation. So while you say the U.S. Constitution fits these expectations of a weak state model, on the one, it's not entirely clear, for example, the U.S. Constitution makes it harder or easier to go to war compared to the Articles of Confederation. There's a higher decision-making threshold, depending on how you think about bicameralism, for example, to going to war under the Articles of Confederation in the U.S. Constitution.
Right.
So what does that mean about how we ought to be thinking about their decision-making choices here? You have a more powerful president and greater resource extraction possibilities in the U.S. Constitution than under the Articles of Confederation. What does that mean about how this fits into this kind of weak state model? Does that mean the U.S. Constitution was a superpower constitution, but the Articles of Confederation was really the weak state? I just don't know. But it means that I think that there are things to be worked out in thinking about the connections between the Articles of Confederation and the U.S. Constitution as sort of two different constitutional systems in the same sort of related time period, and what the various kinds of alternative models might be. The other thing that besides Edling I would point to, which sort of emphasizes sort of the Hamiltonian, we don't want to go through the revolutionary experience of not having the power to fight wars again and have ambitions to be a superpower in the future, and so let's point toward that. The other thing I would note, though, is the kind of Hendrickson, John Eikenberry kind of analysis of the U.S. Constitution, which is focused on solving an internal problem. How do we keep the states from fighting with each other? And so thinking about the U.S. Constitution as solving an internal war, intra-state battle problem, which has also been analyzed in similar kinds of international relations terms, which might be very useful from your perspective in thinking about it in similar kinds of ways, both as a model for how you would think about a paper in this kind of way, but also as an alternative way of grappling with, okay, what is the U.S. Constitution doing, and what kinds of problems is it trying to solve as it creates these kinds of powers.
Now, I think the Articles of Confederation, I mean, that's an important point. I think Jack, when he talked about the prior crises, implicitly makes that point. I think with regards to alternative expectations, I think that I should make it clearer, but I think that they could be, and I don't want to get too much. There's a real tension here in the paper, which I acknowledge, between using the theory as a descriptive matter to explain, sort of come up to a resolution on different point predictions, and then sort of using it as a theory of constitutional interpretation, period, right? I mean, and sort of having the idea that just as Republican theory can inform or is understood to inform the Constitution in a larger sense. This you know, the international theorizing about the context can inform it in general sense. So there is a tension there. Now, alternative expectations, it would be keying into present debates. I mean, much more unilateral presidential power to engage in non-defensive war, right? I mean, much more. The self-executing debate is an interesting debate because the idea is the presumption under U.S. law that a treaty is effective as soon as it's signed, or do you need an implementing statute? And it seems to me that the British rule was a presumption in favor of non-self-executing, which makes sense for a greater power because a great power engaged in a multipolar conflict, but it doesn't make sense for a militarily weak power because treaty breach is treaty breach, and even if you say we didn't stick to our end of the bargain because we didn't have a statute that acted, I mean, it's still a breach under international law, and so it does. You could sort of see alternative predictions. There's a couple where I mean, and Article 3, and I think. And I'm very grateful to Jack for bringing this in because, you know, all my prior work was based on Article 3, and it's clear that they understood that they were doing something very new with the judicial power. I mean, there's the instructions. It says, you know, why do we need the judicial power? And there's the Montesquieuian political theory of it's got to be the equivalent. You know, you have the executive, you have the legislative, and you have the judiciary, and they match up. But they understand. But they have that instruction for national peace and harmony. So they have a very good sense. And then in the early opinions, you see that, you know, this is a different kind of use of judicial power. I mean, they understood that the judicial role they were crafting was in some important sense different, and it was an innovation. And I think that you're right. I mean, in my prior work, I actually focus on the interstate conflict resolution aspect of it. And the Articles of Confederation system is helpful in that respect because they had a different mechanism for resolving interstate debates there. But the international aspect of it didn't kick in, but when they designed it, they thought that that was going to be a really big part of it. It just sort of overcame under the circumstances, but that's not to say that when the original public intent of Article 3 fully understood and viewed the judiciary as a legitimate actor in these things, which is, for example, the political question doctrine as it applies to foreign policy. I think that you have to conclude that that's sort of a very outrageous proposition from an originalist perspective as applied to these kind of cases other than succession and very textual commitments to other branches, specific textual branches, commitments.
One of the things that really hit me when I first came to law school and then the academy after 21 years in the Navy, which, you know, the Navy's almost indisputably the most conservative institution in the United States. We always used
the Marine Corps is probably the most conservative. It's part of the Department of the Navy, so.
Part of the Navy. You know, we used to joke that the Navy's 200 years of tradition unhampered by progress. But the Navy, you know, compliance with international law, and particularly customary international law in the Navy, is absolutely taken for granted. It's part of everything that's done there. And so to come to the academic environment and hear people write these papers and question whether international law is law at all, whether it has any force, you know, just defied my historic reality. Now, I like the paper I thought was really good, and I liked the weak state idea. And I think that Jack is right that there isn't a lot of historical support explained explicitly in the paper, perhaps. I don't think you'd have any trouble going out and filling it in. I mean, the Federalist Papers are just full of exactly what the points that you make. But it seems to me that perhaps you're only telling part of the story. I can understand why, now that I understand that this is international relations theory per se, you know, it makes a little more sense. But it seems to me that along with the sort of weak state things that the founders were thinking about, that the respect for the rule of law that led them to want to create a written constitution and establish a domestic order that protects rights, that they had that same sort of view towards the international environment.
Yeah.
And I mean, I look at George Washington's experience in the British Army, I look at his experience in the Virginia Regiment, the first professional military organization in the United States before the war, and it seems to me that it's consistently colored with an absolute respect for the rule of law, to the point where he ignored guidance from the governor of Virginia, his notional boss, when he felt it conflicted with the law. And so it seems to me that part of the story is the weak state, but part of the story for the Foreign Affairs Constitution may also be this absolute belief in the primacy of the rule of law and the importance of compliance with international law. And the reason I think that's important, obviously, for reasons you can figure, because if this is all just about us being a weak state, then the originalist today is free to say, well, we shouldn't be bound by those rules and we shouldn't care about respect for international law because that was just something we did when we were a weak state. But if, in fact, the founders did incorporate into the Constitution quite deliberately respect for international law as part of the rule of law, then that seems to me that it conveys a very different lesson for us today.
I think, David, maybe in my response to Maimon, I went too far in the other direction, because when I said that customary international law wasn't as important, I didn't mean to suggest that they still had a commitment to rule of law. They just preferred treaties over customary rules, and the problem with customary rules was that they were in many instances pro UK, especially in the commercial context. But for example, in the laws of war context, a lot of the rules didn't favor the United States. The United States was very sort of aggressive about having proactive definitions, creative, innovative definitions about such things as treatment of prisoners of war. If you look at the U.S.-Prussia Treaty of 1785, they have those terms, and what they're trying to do, and obviously they're trying to innovate and kind of propagate a new set of rules. And during the neutrality years, I mean, the U.S. really sort of was at the cutting edge of trying to push customs rules that emphasized the free hulls, free goods principle, and maximal neutrality rights, even to the point of saying that we could sell guns to both belligerents and so forth. So, but I think. Recently, when John Bellinger, who was the director of the legal advisor to the State Department, had this very interesting exchange when the Red Cross had come out with the fancy red books on customary laws of war, and he said, "Well, we don't disagree with the proposal that the U.S. is committed to the rule of law, and there's something called customary international law out there. We just object to the Red Cross's way of counting as practice all these goofy things, which we just have a different way of calculating it, and we would have a much more stringent test," right? And I think that that's actually not incorrect as an originalist matter. I mean, you're sort of coming at it from a different angle, but the U.S. had the same attitude at the founding. They didn't disagree with it in principle. They preferred treaties, and they would insist on a higher burden of proof because the custom rules generally didn't shade your way, which is.
It seems to me that one of the reasons they wanted the treaties, though, was because they felt bound by the customary rules. And unlike people today who say, well, the president must have the authority to break customary international law because how else can you reshape it? It seemed to me the founders were very clear that they had to comply with it unless they had a treaty. And so they used treaties as a way to start to reshape customary international law, believing if we could, for example, codify better treatments of prisoners of war in treaties, that eventually that would morph into customary international law. And we wanted free ships, free goods. We disagreed with the rules that were being applied by international prize courts. So our solution was to try to negotiate treaties that would begin to change those rules because we felt we were totally bound by them to the extent we didn't like them.
Yeah, I mean, I don't think I guess you back me into a corner, and I say that you're right in a sense that the U.S. Really felt that if it was recognized as a rule of custom, they had to follow it regardless of whether they liked it or not, right? And so that's there. I mean, The question of the modern takeaways from all this is an incredibly complicated one. That for example, even if you believe that the courts were supposed to be Article III courts are foreign policy institutions, that there's no problem with them wading into the Guantanamo issues and so forth. The personnel that man the Article III judiciary are not diplomats anymore. They're mostly sort of pointy-headed appellate lawyers with judicial backgrounds, and so that poses a real a problem of translation, I think, because the institution has evolved to such an extent that the originalist view is not so easily translated into action. I mean, that's sort of.
I wanted to ask whether you had figured into your assessment of the infant U.S. as international law actor and foreign policy actor, its relationship with the Indian nations, because there's a whole set of foreign policy concerns they have with them. And we didn't necessarily feel ourselves to be in a strong position.
Yeah, and I put one sentence where I said that, anxieties with the Indian tribes. I mean, the first standing army authorization the U.S. Congress passed was the Legion Act of 1790. Was that right? Where they enacted they authorized the stand up of a and it's funny because they called it a legion and they called the unit centurions because obviously they're trying to invoke the Roman Republican tradition, but it was to fight in Indian wars, and then the frigates came 4 years later to fight the maritime war. But I mean that's I consider that sort of a friendly proposal.
Woody Holton, I think, has done some historical work looking at the Indians as a foreign policy problem.
Yeah. He hasn't? No, that's right.
He has or he hasn't?
Yeah.
Woody makes me nervous.
But it's a start. It's a place to start. That set of questions.
Yeah, but I'm really, let me just interject you. I'm really skeptical about that. I mean, I think it's true situationally that the Indian War of the 1790s is the first big test of the state, building capacity of the United States. And I think about jurisdictionally, I think it's very different. I mean, all the authority of the Indians really does come from the Commerce Clause.
But he's dealing with international relations theory, which would sort of transcend those, like what is shaping our concerns about how this Constitution would work. It isn't necessarily clause bound. That's my. I don't know much about it, so I haven't got.
Well, I mean, it's maybe, and I understand your question now. I mean, to the extent that I'm aware, I tend to think that they were looking the other way, and they understood the tribes as a nuisance and something that was relevant, but mostly in the connection of the other threat, and they didn't really see it as something that they should be worried about when they would have. I don't know. That's just sort of my gut reaction, but.
It's one of the dominant assumptions of the late 70s, or I won't say dominant, but it's one of the strong assumptions of the late 1790s that Indians, at least east of the Mississippi, may well disappear in shorter order rather than longer order. They'll drift off, or they'll be assimilated, or they'll die off, or some combination of those things.
Well, the 1790 Crimes Act is very interesting because it treats Indian tribes. I mean, it actually gives the Indians more rights than you think they would, and I think it's under the impression that they're just not going to be around for very long, and so it's not a big deal because the real. I don't know. And then later on, they start having real problems when they realize, in Florida and Georgia and the southern states really kind of, and then along the, but it's interesting to think of. Yeah, good point.
Well, I had another point, but I just quickly want to disagree with some of the dismissal of the Indian threat here. Just real quick, you're as you know, the first standing army that created a deal with the Indian government promptly got crushed in one of the worst military defeats we ever.
But that was because the Legion was so bad, right? And everyone agreed that
he basically didn't control any of that territory in the Northwest Territory, and indeed. It was the Indians were in close alliance with the British, who continued to occupy the coasts up there. So
but and I guess this was sort of part of my response to Garrett, Mike. But didn't you think that they viewed it in conjunction with the British threat in the Northwest Post? I mean, they didn't think that they thought the Indians were a threat because they were sort of the auxiliaries of the British, so to speak, right? I don't know.
Right, yeah. But I think, well, anyway, I don't want to get into this because I actually want to go in a different direction, but I just had to register some concern. But the question I wanted to ask, though, was how much work you see this idea of the weak state doing in the interpretation. And I think this is a great paper, and I think it's a great way to think about the international position they were in at the time. I think it's absolutely right about that. But it's when you're going through your examples, I thought there are different weights you could give it. And so on the treaty point, for example, on the self-executing treaties, you sort of say, well, the strongest view seems to be that most or all treaties were self-executing. There's been some disagreement in modern times, but this sort of reinforces the traditional account.
Right.
I think that's exactly right. And I'm 100% on board for that. And I might offer as a friendly additional example the idea that you referred to it a little bit, but the idea that the president has very limited offensive power, but perhaps, and I would say he does, by the text itself, have very broad defensive power. And that's what you would expect from a weak state. Because if you're a weak state, if you're afraid of being attacked, and you're afraid that if you are attacked, you're going to collapse very quickly.
A weak decentralized state.
Unless you can get something going quickly and not wait around for Congress to authorize it. So I would use it sort of as a sort of reinforcing where the text seems to be going. But then some of your examples seem to go somewhat beyond that. So you say that I'm not in light of the colloquy, I'm not really sure how far you're going with this, but you say that incorporating international law, customary international law, into domestic constitutional law, and if perhaps you mean something like having it as federal common law, as the modern view is, well, I guess I would say that the text of the Constitution and the application of the Constitution after ratification doesn't support that. So the question is, would you then use sort of a weak state model to override what seems to be the natural or the better reading of the text and the context of the time? And then I think you take it even a step further when you talk about international delegations, because you say that this would support the idea that you could do delegations to multilateral institutions. But here, you're not really reinforcing an interpretation of a text or intent, because there were no multilateral institutions then, and so the weak state model would not have led them to adopt this view at the time, because the option just didn't exist. So what you're really saying now is we're going to use the weak state model to address a changed circumstance that they didn't confront. But if they had confronted it, we're going to use the weak state model to sort of answer it. So it seems to me that each step of that is moving more and more weight onto the weak step, and into the weak state. And I wonder if at least one, if not two of those, is a bridge too far.
To evoke the classic war film, the Cornelius Ryan book. So two responses. One about international delegations. I actually have been thinking about that, and I think that perhaps what I want to do is to say that they'd be comfortable with international delegations for the purposes of adjudication only, right? And I mean, because the Jay Treaty set forth the U.S.-UK mixed claims tribunals, and which is a bilateral sort of multinational or multilateral, but a bilateral arbitration association, and the U.S. really. In the early, I mean, and this is not 18th century evidence, but in the early 1800s, I mean, they were really bully into using this particular solution. So I think it's consistent. So it goes back to what Jack was saying about the judicial power. They were very interested in using what we might call ADR techniques, and so. But I do agree with you that that's that's a separate point from the idea of delegation for lawmaking or executive functions, because they had real problems with alliances, and the 1778 Treaty of Alliance with France was an albatross for a very long time, and so I do think that they and lawmaking usually meant you'd have to spend some money, and they would have been really suspicious about that. So maybe I'd like to toe the line and say that it does seem to me that if you could use a delegation for conflict avoidance and dispute resolution, that would actually probably be okay, right? Now, with regards to the point about defensive and offensive, I mean, that makes a lot of sense to me, and this is something that you talk about in your book, and this is a big point of yours, but I think that if you're in the context of a weak, decentralized state and you are actually attacked, and granted there are very difficult questions about the threshold level of attack, it makes a lot of sense to say that the executive under those circumstances can do a lot in a defensive war situation. And that's why I suggested, notwithstanding Taney's opinion in Merriman, I mean, perhaps Lincoln had the better of the suspension argument, even though that clause is located in Article 1, Section 9, and emergency, the Constitution. And this is something Jack Balkin has written about. I think that an originalist perspective is consistent with a pretty robust emergency constitution, so long as you trip the threshold of defensive war. Now, that makes it. That's really makes it difficult, because the threshold of a defensive war has become so much more complicated now than they could have possibly envisioned. But I think that's actually right. As regards to customary international laws, federal common law, I don't think that they thought about that in the modern formulation. I just don't think the issue was as serious for them as it is for us today. And I think it reduced to the idea of denial of justice only. So that's not a very satisfying response. But yeah.
Yeah, I kind of perked up at the discussion of the Indian tribes that Garrett and then Mike Ramsey discussing. It's a fantastic paper in general, but at risk of maybe pursuing that angle, I certainly wouldn't claim to be a historian of U.S.-Indian relations, but I've taught American Indian law for 14 years, and it would be my impression, just from the impressions I picked up, that the treaties with the Indians would have to be a significant part of understanding what treaties meant for what impact that has.
It certainly has in treaty jurisprudence.
Yeah, and I might have overread what Jack Rickhoff was saying, but I think it would be a mistake to think that only the commerce power would be the primary thing to look at with the Indians, because there were hundreds of treaties with the Indians between 1778, actually, and when they stopped in the 1870s. And Chief Justice Marshall in Worcester v. Georgia summarizes the legal framework governing relations with the Indians. He leads off, I think, with the treaty power and the war power. Commerce power comes in third. And I think the conception of the commerce power then was a fairly modest conception. It really was just regulating the trade with the Indians, primarily the non-Indian traders. It wasn't envisioned as a source of power to govern or control Indians. Right. That was done militarily, politically, through the treaty power. Now, all of that changed, of course, radically over time. And my impression agrees with Michael's that the Indian tribes were very powerful at these early stages. There was a hope they would die off, but at the same time, there was starting 10 or 15 years after the Constitution's frame, there's a sense that we have to remove them forcibly, which is in some tension with the idea that they would die off, because there's this very deliberate policy of forcing them to remove West.
Right.
So anyway, that's just my
No, I mean, and I think that, and there's 2 points there. One is sort of, and is a framing issue. I mean, I'm really looking at 1787 to 1793, and it's clear that the complexion of the problem changed pretty quickly. And I do think that but as I said, I think that in terms of like what we would call sort of Metternickian world politic calculations. So I don't know if you're suggesting that because of the Indian tribes, the U.S. felt it was a middle power, or somehow the theoretical orientation should change.
What was the significance? I'm sorry, the dates. But you're saying that because you're
right. I think from 1787, 1793, they understood the Indian issue as essentially a supplement of the European great power issue, and that it wasn't going to be so important that it would sort of affect their balance of power how they would design the foreign affairs constitution blueprint in a meaningful
that
way.
might or might not be true. Because after the Treaty of Peace in 1783, you get some very important treaties with Indian tribes, like with the Cherokees in 1785. So right in that middle 1780s period, there's some very important treaties. They were allies with the British, but that war is over, and now they're confronting a potentially hostile.
Now, I'll definitely look at it.
So it might be more in play, but I'm certainly not an expert on it. I'm not.
Okay.
So I'm glad I got to the queue at this point, because I have a question that takes a little bit off the heart of the paper, which I thought was really interesting, I certainly learned a tremendous amount from it. But the question is this: so you've got the weak power model, right? And then that's doing work with respect to the Constitution. And my question is, exactly what kind of work do you think it does? Right. So one kind of work it would do, it would be explanatory, right? As a matter of positive theory, it might be that the weak power model explains why the Constitution has the features it does. In that case, it's a claim, it's a claim about causation, right? And it's not really an originalist claim at all. A second possibility is that you believe that the weak power model provides us with an understanding of what the purpose is, right?
That's right. I
the
think
provisions are.
Like, for example, the judicial power. When they say judicial power,
So that's very interesting. But then I wonder what specific theory of originalism, right, would make those purposes relevant to contemporary questions of constitutional meaning. And in particular, I think you would run into a problem with public meaning originalists who would say that what we're after is the linguistic meaning of the text, and so these purposes might be relevant if there's an ambiguity, but what are the ambiguities? And if you're an intentionalist, right, of the Larry Alexander variety at least, I think you're interested not in the purposes, but in the linguistic intentions or semantic intentions of the framers. And so once again, it might be relevant to ambiguity, but what are the ambiguities to which it is relevant? It's possible that you think something else entirely. That is, that you don't think that what the model gives us is an account of the linguistic meaning of the Constitution, but instead you think that the original purpose as encapsulated in the model is relevant to the process of constitutional construction with respect to the provisions of the Constitution which may have vague semantic content, like judicial power, right, where the boundaries are not clear. Or it may be that you have some other theory in mind. But my question is, in what way do you think that your account is relevant to originalism as a view about contemporary constitutional practice?
Well, I mean, I guess maybe I just am not, am thinking about the problem in too narrow a frame, but basically, like let's take the original jurisdiction of the Supreme Court as an example, right? I mean, everyone here is talking about the judicial role in the constitutional republic, and as a textual matter, I mean, whether you agree with it as a normative matter or not, Congress could wait for all the judges to die, and then they could just kill off all the district judges, and they could leave the Supreme Court with jurisdiction over ambassador cases and interstate controversies, and that would be okay, right? I mean, I believe, I consider my originalist because I actually believe that that's the meaning of Article 3, Section 2, right? And so if that's what I believe, then it makes an important statement about, what we think the judicial role in a constitution. I mean, everyone thinks Marbury versus Madison judicial review is the main event. I'm just trying to say, in fact, they actually thought this would be the main event. It became obvious right away that it wasn't gonna be, and it didn't fulfill the function that they wanted it. But really, all I want to say is, I'm just sort of asking a basic question, I mean, as a student of Article 3, I've come to this weird realization, and I think it's an originalist realization, and that it has something to say about the judicial role. I mean that's it's not one that I had expected, but it seems to me. I mean, I don't know if that's a satisfactory answer.
Whether you'd like to have the last word, last question.
Okay, I will. First a comment and then a question. A comment, I think, Tom, just on the colloquy you just had. I think the mode of reasoning you're talking about, pointing to the functional importance of the public minister's jurisdiction, is essentially a structural argument. Structural argument may be used to clear up some lack of clarity regarding, say, the exceptions power. The question I want to ask is, you've been emphasizing the federal courts as a foreign policy institution in the early days. I wonder if they're really a foreign relations institution rather than a foreign policy institution. And the really important thing, say with respect to the general law and the law of nations, without regard to how it would work in the American legal hierarchy, is just for them to have jurisdiction over cases as opposed to the state courts, because they would be so much more likely to be genuinely impartial between American interests and the interest of foreigners, and therefore much less likely to get us into trouble with other countries.
Right. Now, I mean, if you look at the, I mean, whether you call it a foreign relations or a foreign policy institution, so if you look at the Judiciary Act of 1789, which is sort of the Rosetta Stone of Article 3, and has a special place. It creates 21 Article 3 judges, and the district judge in each state is essentially the only federal officer on the ground at the time, right? And you could phrase it so what is the business of these guys supposed to be mostly? And it's supposed to be dealing with foreign interests and allowing foreign creditors to or out-of-state creditors to bring debt actions and the occasional tort action in a federal court before a federal jury rather than in a state court. Now, you could look at it one way and say that that's just kind of like a forum provision in a civil procedure kind of way. You could look at it another way and say really that's their solution to a substantive foreign policy problem they had about credit and issues of keeping the lines of exchange going and having influential English creditors complain to the king and having these problems come to a head. And so, in essence, I think you're right. I mean, it looks like a foreign relations institution in hindsight, but that's because that happened to be one of the big foreign policy issues because of Article 4 of the Treaty of Peace. Now, it's very interesting because very quickly the federal district courts, after the Jay Treaty, sort of devolve into a different function, and they handle a lot of these they during the neutrality controversy, they handle a lot of the restitution actions for the French privateers and so forth, and so they move into a different line of business than the original business. But once again, I mean, you could classify that as a foreign relations institute, but if you consider something like Jefferson's letter to Jay with the 29 questions that Jay refuses to answer, you look at that and that's clearly a request for foreign policy advice. And those issues are actually being handled by the district judges in the cases that are being litigated on a daily basis, like B and these cases. And so I see your point, but I just wonder if it's as valid to consider them, to wonder if the distinction is a meaningful one.